Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to provide you with the 5 steps to a Chapter 7 bankruptcy. We're going to go step by step through the whole process. You'll understand what it is, how it'll impact you, and help you to determine if it's a good option for dealing with your debt problem. But if this is your first time here to my YouTube channel, please click subscribe, check on that little bell. That way you'll be notified each and every week, actually each and every day, when I put out new videos that'll help you deal with your serious debt problem. All right, let's talk about Chapter 7 bankruptcy. Now, I'm recording this in 2023, and this is an update to a video that I had done in the past that's similar because there have been some changes in the bankruptcy process, particularly post-COVID-19, the way the courts handle it, the way the cases are processed. So I wanted to go through that with you so that you can have an understanding of what it is if it's something you're considering to deal with your debt problem. Now, I am a bankruptcy attorney in the state of Arizona. My contact information is below this video. If you're in the state of Arizona, I'd be happy to see if I can help you. But I want to break the Chapter 7 process down into 5 different steps or areas so that you can understand really what it is. The first one is really what we consider in my office the pre-filing step. This is when a lot of the information is being gathered, documents, different things that your bankruptcy attorney is going to need to actually draft what's known as the voluntary petition and the schedules. Now, you've got to know right up from the get-go that bankruptcy is a very intensive paper information document type process. There's just a ton of information that they require. The typical Chapter 7 bankruptcy filing is nearly 100 pages long, full of information on you, your creditors, your assets, your budget, your income, financial transactions. So you need to kind of get into that mindset that if you're going to go through the bankruptcy process, you're going to have to work with your attorney very closely to gather all the information and the documentation that's necessary. That first step, that's what a lot of that is. It's gathering information, it's gathering documents so that your bankruptcy attorney can draft the things that need to be submitted to the court. Now, before your case is filed, it's important to know you also are required to take an online credit counseling class. This is not a big deal. It's literally like a 1-hour video you watch online. It gives you some just general information and pointers on dealing with debt and dealing with finances. At the end of it, you'll get a certificate that says you took it. You did the class. There's nothing that's really tricky or very intricate about it. It's just something you have to do before your case is actually filed with the court. All right, the second step is the actual filing of the bankruptcy documents with the court. Now, with my office, with most Chapter 7 cases, we filed the voluntary petition first. That initiates the case. That gets you a case number. And probably most importantly, it triggers the invoking of the automatic stay. The automatic stay is an order that's entered by the judge in your case that stops all collections. We're talking no phone calls, no letters, no emails, no nothing. They can't take anything out of your account. They can't sue you. They can't garnish you. All collections stop as soon as that initial voluntary petition is filed with the bankruptcy court. Now, in most of my cases, the schedules and the statements or the bulk of the rest of the information and documentation is submitted about 2 weeks later. But the initial petition can be filed very quickly, and this is very helpful if you're dealing with like a wage garnishment or a debt collection lawsuit or something where you just need to stop the collections and you need to do it quickly. You can get that petition prepared, filed, and stop the collections going forward. We can literally do it same day. We don't always prefer to do that, but it can happen that quickly if you take your credit counseling class, get the petition drafted and submit it to the court. That will stop all collections. And then, like I said, about 2 weeks later, all the rest of the information on income and budget and assets and all of that is submitted later. That's the rest of that 100-page document. Now, the third step is the meeting of creditors. Sometimes it's called the 341 meeting. 341 just references the bankruptcy code provision that provides for this meeting. The 341 meeting, or the meeting of creditors, it states in the bankruptcy code that everybody who goes through the bankruptcy process must participate in a meeting of creditors. Now, it sounds a lot more ominous than it really is. The meeting of creditors is really a meeting between you, your bankruptcy attorney, and usually the bankruptcy trustee. Now, the bankruptcy trustee is not the judge in your case. The bankruptcy trustee is a person who works for the Department of Justice. Their job is to review your case, make sure you have all the documents submitted properly, and they're also going to look to see if there's any assets that can be sold and the proceeds given to your creditors. Now, in most Chapter 7 cases, people don't really lose anything. Statistics I've seen is over 95% of people don't lose anything that go through the Chapter 7 process. And that is because there are various exemption laws on the federal level as well as in the state level that protect most assets. Like 401ks, IRAs, those are protected assets. In most states, there's a homestead exemption that can protect a certain amount of equity in your home. There's exemptions for vehicles, household goods, those types of things. So, but the trustee's job is to review this and see if there is anything that could be sold with the proceeds then given to your creditors. The trustee will do handle the meeting of creditors. The meeting is very brief. In most cases, it's about 5 minutes long. And one really nice and convenient thing is ever since the COVID-19 pandemic, these meetings are done virtually. In Arizona, most of them are done over the telephone. However, so there's a couple trustees that do them via Zoom, but you no longer have to go down to the courthouse, which is what we used to have to do. You travel all the way into Phoenix, and they have them throughout all the state in Arizona. This is nationwide. They're done virtual, and we've heard from the U.S. Trustee's Office on the national level that this is a permanent change, that the meetings of creditors will now be virtual in all 50 states, and this is going to be something going indefinitely into the future, which is really good for you because you don't have to miss a day of work or anything like that. It's literally a 5-minute phone call. The next step, the fourth step, is really kind of the post 341 period, or the post meeting of creditors. Really, in most cases, most Chapter 7s, not a whole lot is going on during this time period, at least as far as what you will see. Often your bankruptcy attorney is working with the trustee if there's any additional documents or information needed. If there are any assets that are going to be sold, that'll be happening as well with the bankruptcy trustee, and your attorney will help coordinate all that. For the most part, your main thing that you need to do at this stage is there's a second financial management class that you have to take online. Again, it takes about an hour, and it's just an informational course, but you have to take that. They will not enter your discharge, which is the order that you're going after, unless you take that financial management course. And then the fifth and the final step is the discharge order. I always say it's a little bit anticlimactic. You know, there's so much emotion and energy that goes into your bankruptcy process and even the decision to file for bankruptcy. And then when it all comes to an end, you just get a letter in the mail that says discharge across the top and is signed by your judge. But that's an important letter because it's also sent out to your creditors, both in the mail and electronically. And it lets your creditors know that all the credit cards, medical bills, personal loans, those unsecured debts, they have been eliminated completely. They are discharged. They can no longer collect them from you. And even on your credit report, they'll be zeroed out. They're going to show that no balance is there and that the debt was discharged in bankruptcy. It's important to know that other types of debts, a lot of taxes, student loans, child support, alimony, those types of debts often do not go away, as well as secured debts, like your mortgage or your car loan. A good rule of thumb is if you want to keep your house, if you want to keep your car, you need to continue to make the payments on it. If you don't do that, then they can repossess, they can foreclose. So those types of debts are treated a little bit differently than what we call unsecured general non-priority debts, credit cards, medical bills, personal loans, those types of things. So in Arizona, I know from the day your case is filed with the court until they enter that discharge order, right now takes about 4 months from beginning to end, which 4 months is a long time, but when it comes to federal court proceedings, it's smoking fast. You're going to get through that quicker than most other federal type of proceedings. Now, once your discharge is entered, while that does show that your debts are now legally discharged, it does not mean that your case is completely over. The case will then be administratively closed by the clerk of the court, usually about 30 days later. If there are any other outstanding issues with the trustee, if they need information or if they need documents, often if they need tax returns, they're not going to close out your case completely until those things are dealt with. So just knowing that once the discharge is entered, there's still additional information and things kind of going on behind the scenes. But once the clerk closes that out, you now know that everything is done. You've done everything you need to do. You got your discharge and you made it from beginning to end. So hopefully that clears up a lot about the Chapter 7 bankruptcy process. Again, I'm a bankruptcy attorney in the state of Arizona. I do free consultations. We can file most cases for no money down and then break it up into small payments, and we can do it very quickly. So if you're facing wage garnishment, if you're facing bank levy, debt collection lawsuits, whatever it is, it's good to talk to an attorney like myself and determine if that's a good option for you. Again, check my information out below, and thanks for watching today.